Hello everyone, I am Neelam Vaishno. Today in this video, we will be learning about mastering Indian Constitution. So let's get started. By the end of this video, you will be able to understand, demonstrate expert knowledge of the Indian Constitution and its various components, critically analyze constitutional amendments, interpretations, and landmark cases. Engage learners with interactive and practical teaching methods for constitutional topics. Develop and assess course material, exams, and activities focused on the Indian Constitution. Foster a comprehensive understanding of India's legal and political system among students. In the first module, we will begin with the introduction to the Indian Constitution. So let's move ahead. The Indian Constitution is the supreme law of the country, adopted on November 26, 1949 and enforced on January 26, 1950. November 26 is celebrated as Constitution Day and January 26 is celebrated as the Republic Day of India. At the time of its adoption, the Constitution contained 395 articles and 8 schedules and was about 1,45,000 words, making it the longest written constitution in the world, providing a framework for governance, rights, and duties. Proceeding ahead, let's look at the pre-independent historical background of the Indian Constitution. Before India became independent in 1947, several acts and reforms influenced its constitutional development. The first was Regulating Act of 1773, was the first step taken by the British government to control and regulate the affairs of the East India Company in India. Peace India Act 1784 brought dual control by the British Crown and East India Company. Charter Act 1793 to 1853 expanded British influence and administration. Government of India Act 1858 ended East India Company rule, bringing direct British control. Indian Council Act 1861 and 1892, a law was passed by the British Parliament to increase involvement of Indians in the legislative process. Monumental Reform 1909, this introduced separate electorates for Muslims. Government of India Act 1919 introduced diarchy. It is also called as dual government. Government of India Act 1935 laid the foundation for the federal structure, dividing powers between the center and the unit states, regarded as a reference for the Indian Constitution. And the last one, Indian Independence Act 1947, divided British India into India and Pakistan, granting independence. Continuing further, let's understand some details on the Constitution Assembly. Pandit Jawaharlal Nehru suggested that the Constitution of Free India should be made by a Constituent Assembly elected on the basis of adult suffrage without any outside interference. The Constituent Assembly was formed in 1946 to draft the Indian Constitution. It constituted a total of 389 members initially, which was reduced to 299 after partition. Dr. Rajendra Prasad was the chairman of the assembly. Dr. Babasaheb Ambedkar headed the drafting committee. The Constituent Assembly held its first meeting on December 9, 1946. The Constitution was adopted on November 26, 1949, which meant the Constitution making process took 2 years, 11 months, and 18 days. The Constitution of India came into effect from January 26, 1950. Moving ahead. Now let's look at the key sources that influence the Indian Constitution. The Indian Constitution draws inspiration from various historical documents and global constitution. Below are the major influences and sources. Starting with focusing on Indian historical sources. The Government of India Act 1935, the most significant influence providing federal structure, Office of Governor, Judiciary, and Public Service Commissions, emergency provisions, and administrative framework. Indian Independence Act 1947 established India as an independent nation and provided the legal foundation for Constituent Assembly. The international influences to the Indian constitutions are the key contribution from British Constitution were parliamentary system, rule of law, single citizenship, bicameralism, Lok Sabha and Rajya Sabha, speaker's role. And also the US Constitution inspired fundamental rights, independence of the judiciary, judicial review, president's impeachment procedure, which were essential elements. Directive principle of state policy were influenced from Irish Constitution. The federal structure of Indian Constitution is based on Canadian Constitution, which inspired federalism with a strong center residuary powers with the Union. Australian Constitution influenced concurrently shared powers, freedom of trade and commerce. Emergency provision, suspension of fundamental rights were taken from Weimar Constitution, Germany. French Constitution provided references to republicanism, ideals of liberty, equality, and fraternity. From the South African Constitution, we adopted procedure for constitution amendments. The elements of Indian constitutions like fundamental duties, social and economic justice were adopted from USSR Soviet Constitution. Last but not the least, Japan Constitution is influenced procedure established by law. So this was the brief introduction on the Indian Constitution. Let us now learn about what are the fundamental rights and duties of the people of India as mentioned in its Constitution. Fundamental rights are defined as the basic human rights of all citizens. These rights defined in Article 12 to 35 of Part 3 of the Constitution are applied irrespective of race, place of birth, religion, caste, creed or gender. Fundamental rights were borrowed from the Constitution of the United States of America. Part 3 of the Constitution of India specify the below fundamental rights guaranteed to the citizen of India. The first one, right to equality. Article 14 to 18 is one of the important fundamental rights of the Indian Constitution that ensure equal protection for everyone before the law. These rights also include the abolition of titles as well as untouchability. But alongside the reservation policies and special protection for weaker sections are the some limitations of the rights to equality. Right to freedom. Article 19 to 22. Freedom is one of the important ideals cherished by any democratic society. The rights to freedom include freedom of speech, expression, assembly, association, practice any profession or resides in any part of the country. But some of these rights are subject condition of state security. This means the state has the right to impose reasonable restriction on them. Right against exploitation. Article 23 to 24. This right implies the prohibition of traffic in human being forced labor. An exception is that the state can impose compulsory service for public purpose such as military service, social service. Right to freedom of religion. Article 25 to 28. The Constitution of India guarantees the right to practice and propagate any religion to not only individuals but also religious group in India. The state can impose restrictions for public order, morality and health. Cultural and educational rights. Article 29 to 30. It safeguards the rights of linguistic and religious minorities and provides them with a right to establish their educational institutions, which are subject to state regulation on education standards. Right to constitutional remedies. Article 32. The Constitution provides for legal remedies for the protection of these rights against their violation by the state or other institutions, individuals. It entitles the citizens of India to move the Supreme Court or High Court for enforcement of these rights. But during national emergency, these rights can be suspended as the rights are not absolute. Moving on to the fundamental duties and their significance. Fundamental duties are defined as the moral obligations of all citizens to help promote a spirit of patriotism and uphold India's unity. Fundamental duties were added to the Indian Constitution by the 42nd Amendment Act 1976 under Article 51A. Inspired by the Soviet Constitution, they aim to promote civic responsibility among citizens. Every citizen shall abide by the Constitution and respect its ideal, the national flag and the national anthem. Cherish and follow the noble ideals of the freedom struggle. Uphold and protect the sovereignty, unity and integrity of India. Defend the country and render national service and when required. Promote harmony and brotherhood, avoiding practices derogatory to the dignity of women. Value and preserve the rich heritage of Indian culture. Protect and improve the natural environment. Develop scientific temper, humanism, and spirit of inquiry. Safeguard public property and abjure violence. Strive toward excellence in all spheres of individual and national life. Provide opportunities for education to children 16 to 14 years. Let us now learn the importance in governance of the directive principle of state policy. The directive principle of state policy are guidelines for the government to establish social and economical justice in India. These are ideals which are meant to be kept in mind by the state when it formulates policies and enact laws. Borrowed from the Irish Constitution, they are listed in Part 4, Article 36 to 51 of the Indian Constitution. These directive principles of state policies are classified into three key provisions: socialist principle, Gandhian principle, liberal intellectual principles. The detail of these provisions are as follows. Socialist principle: promote welfare state, ensure equal pay for equal work, protect workers' rights, provide free legal aid, and improve public health. Gandhian principle: promote village panchayats, encourage cottage industries, protect the environment, and prohibit intoxicating substances. Liberal intellectual principles: ensure uniform civil code, protect historical monuments, and promote international peace. The importance of directive principle of state policies is based on below 4 points. Directive principle of state policies guided policy making. Simply from the definition of DPSPs, these help the government frame laws for social welfare, promote economic and social justice by ensuring equal opportunities, especially for weaker sections, as underlined by the socialistic principles, bridges rights and duties, balances fundamental rights with state responsibilities, ensure progressive legislation, influences key laws like the Right to Education Act, Manrega, and National Health Policies. Now let us understand details of the structure of the Indian government. The structure of the Indian government is a complex and comprehensive system designed to manage a vast and diverse country. The government operates at both the central and the state levels, ensuring a balance of power and responsibility. The governance framework is divided into three main branches: legislative, executive, and judiciary. Each branch plays a crucial role in the functioning of the government, maintaining checks and balances to prevent any one branch from becoming too powerful. Legislature, responsible to make laws. The Parliament of India at union level is the supreme legislative body and consists of two houses: Lok Sabha, House of the People, and Raj Sabha, Council of States. And at the state level, the equivalent legislative bodies are Legislative Assembly and Legislative Council. The Lok Sabha is the lower house with members elected directly by the people of India. It is responsible for making laws, and the government must maintain the confidence of the majority in the Lok Sabha to remain in power. The Rajya Sabha is the upper house with members elected by the legislative assemblies of the state and union territories. It represents the states at the national level and has a role in reviewing and suggesting amendment to legislation proposed by the Lok Sabha. The other roles and function of the legislative body is control government finances, budget, taxation, public expenditure, supervises the executive, amend the constitution when necessary, represent the voice of the people. The executive, responsible to enforce laws. The executive body at the central level is headed by the President of India, who is the ceremonial head of the state. The real executive power, however, lies with the Prime Minister and the Council of Ministers. President of India is the formal head of the executive, legislature and judiciary, and also the commander in chief of the Indian Armed Forces. The president power include appointing the prime minister, dissolving Lok Sabha and issuing ordinance. Prime Minister and Council of Ministers. The Prime Minister is the head of the government and lead the Council of Ministers. Together, they are responsible for implementing laws, formulate policies, administer governance, handle foreign relations, defense, and national security. The executive body at the state level consists of governor, chief minister, and state council of ministers. Judiciary, responsible for judicial review by interpreting laws. The Supreme Court of India is the highest judicial authority in the country. The judiciary at the state level is headed by the High Court, with a hierarchy of subordinate courts beneath them. Each state has a High Court which has the powers of judicial review over the laws and the action of the state government. Subordinate courts include district court, which ensure the administration of justice at the grassroots level. The Supreme Court ensures that laws and action of the government comply with the constitution. It hears appeals from lower courts and has originally jurisdiction in disputes between state and the central government. The governance structure in India is designed to ensure efficient administration and uphold democratic principles. Moving on, the understanding the distribution of powers among union, state and concurrent list. The Indian Constitution follows a federal structure distributing power between the union, center and states through three lists in the 7th schedule, article 246. The union list has 97 subjects. The parliament has a supreme power over the items on this list. The union list deals with nationally important subjects like defense and army, foreign affairs, railways, banking and currency, atomic energy. State list. The state list contains 66 subjects. The state legislature has supreme powers over the subjects on this list. The state list deals with police, law and order, public health, agriculture, state, public service, fisheries. Concurrent list. The concurrent list has 52 subjects. Both the union and state have powers over the subjects on this list. Union law prevail in conflicts. The concurrent list deals with education, marriage and divorce, forest and wildlife, criminal laws, trade unions. Let us try to understand the unique characteristics of federalism in India. Federalism is a system of a governance where power is divided between a central authority and regional government states. Federalism are of two types: coming together federalism and holding together federalism. Coming together federalism, where smaller states come together to form a big union, example US, Australia. And in holding together federalism, where a big union disintegrates power among smaller regions, example Canada, India. India follows the quasi-federal structure, meaning it has features of both federal and unitary system. Below are the characteristics of federalism in India. Dual government. Power is divided between the union, center and states. Three-tier system. Governance exists at central, state and local levels. Panchayati Raj and municipalities. Division of powers defined by the 7th schedule dividing subjects into union, states and concurrent list. Supremacy of constitution. The constitution is the supreme law and both center and states derive power from it. Strong center. Unlike the USA, India gives more power to the center, allowing it to overriding states' laws in certain cases. Single citizenship. Unlike fully federal countries, India provides only single citizenship, not state-wide citizenship. Independent judiciary. The Supreme Court safeguards the constitution and resolve center-state disputes. Flexibility in federalism. In times of emergency, India becomes more unitary, giving the center overriding powers. Equal representation in Rajya Sabha. States have proportional representation in Rajya Sabha. So, now the question is India truly federal? The answer to it is India is a quasi-federal, which is because it has a strong center with overriding powers. States are not entirely independent in lawmaking. Emergency provisions, Article 352, 356 can centralize power. The governor appointed by the center and influence state governance. However, India's federal structure ensures unity in diversity, balancing centralized authority with regional autonomy. In this module, we will understand the details about the President, Parliament and the Supreme Court. The President of India is the constitutional head of state and the supreme commander of the armed forces. However, India follows a parliamentary system, so the President acts on the advice of the Council of Ministers mentioned Article 74. The President has 6 types of powers which are described as follows: Executive power. Being head of the executive, all government actions are taken in the president's name. The president appoints the prime minister, governors, chief justice, and key officials. Also administers union territories through lieutenant governors. And the president can issue ordinances article 123 when parliament is not in session. Under the legislative power, president summons, prorogues and dissolves Lok Sabha and Rajya Sabha. He addresses parliament at the start of each session. President can grant assent, returns or reject bills except money bills. He nominates members 12 to Rajya Sabha experts. Financial power. With financial powers, all money bills require the president's prior approval. The president controls the contingency fund of India and constitute the finance commission every 5 years. With the judicial power, president appoints judges of the Supreme Court and High Courts and also can grant pardon, commutations and remissions under Article 72. With diplomatic and military powers, the president represents India in foreign affairs, appoints ambassadors and diplomats. He also signs international treaties. Being Supreme Commander of Armed Forces, appoints Chief of Army, Navy and Air Forces. He can declare war or peace on Cabinet's advice. Emergency power. Using emergency powers, the President can impose national emergency, mention Article 352 during war or rebellion. Declare state emergency, Article 356, President's rule in states. He can impose financial emergency, Article 360, due to financial crisis. Now let us focus on the structure and functioning of Parliament of India. The Parliament of India is bicameral consisting of Lok Sabha and Rajya Sabha. Lok Sabha. Lok Sabha, also called the lower house, which constitutes 543 members elected directly by the people of India to serve a 5-year term. The speaker elected by the members of Lok Sabha is the presiding officer of the Lok Sabha. And the Rajya Sabha, also called the upper house, constitute a total of 245 members elected by the legislative assemblies of the states and union territories, where 1/3 of the members retire every 2 years. The Vice President presides the Rajya Sabha. President of India is the formal head of the Parliament. The President is empowered to approve bills or summon sessions. Moving ahead, to understand the functions of the Indian Parliament. There are 6 major types of functions of the Parliament: legislative, financial, executive oversight, judicial electoral, emergency powers. Let us further understand the functions of Parliament under these categories. Legislative functions of the parliament include making laws on union and concurrently subject amends constitution. Under the financial functions, the president approve budget, finance bill, control public expenditure with the responsibility of providing executive oversight. The parliament can remove the government via no confidence motion. Also, ministers are answerable to parliament. Under the judicial functions, the parliament can impeach the president, remove Supreme Court and High Court judges whenever required or necessary. So, with the help of electoral functions, the parliament elect the president, vice president, speaker, and deputy speaker. Emergency powers of the parliament are essential control during national, state, and financial emergency. The Supreme Court of India is the highest judicial authority in the country. The Supreme Court constitutes a maximum of 34 judges with one elected as the Chief Justice of India. The Supreme Court judges are appointed by the President based on recommendations from collegium system. The Supreme Court has the power of judicial review, ensuring that laws and actions of the government comply with the Constitution. The retirement age of the judges is 65 years. The jurisdictions of the Supreme Court are of four types. Original jurisdiction. Under original jurisdiction, the Supreme Court of India handles disputes between the center and the states, enforces fundamental rights mentioned Article 32. Appellate jurisdiction. In this jurisdiction category, the Supreme Court hears appeals from High Court in civil, criminal, and constitutional matters. Advisory jurisdiction helps President of India to seek legal advice on constitutional matters under Article 143. The last category is writ jurisdiction, under which the Supreme Court issues writs like habeas corpus, mandamus, prohibition, certiorari, quo warranto, in order to protect fundamental rights. With the power of judicial review, the Supreme Court ensures laws follow the Constitution, strikes down unconstitutional laws, checks executive and legislative actions to prevent misuse of power. Based on doctrine of basic structure established in Keshwananda Bharti case 1973. In this module, we look to understand the procedure of constitutional amendments and constitutional evolution. The procedure of constitutional amendments as specified under Article 368 has been adopted from the South African Constitution. The process of constitutional amendments are categorized under three categories: simple majority, special majority, and state ratification. The categorization depends on the subject of constitutional amendments. Simple majority is used for amendment to parliament, rules, state boundaries, etc., which requires majority of members present and voting in both houses of parliament. Special majority is used for amendment to subjects like fundamental rights, DPSPs, etc., where it requires two-thirds majority of members present and voting in both houses. Special majority along with state ratification is used for changes to federal structure, example High Court, President, elections, which requires two-thirds majority in parliament and approval from at least 50% of state legislatures. What is the importance of constitutional amendments? The constitutional amendments ensure flexibility as it allows the constitution to adapt to social, political and economic changes. It helps protect fundamental rights as it helps strengthen and expand rights. Example, right to education added by the 86th Amendment. Constitutional amendment strengthen democracy as it enables reforms like anti-defection law, 42nd Amendment and Panchayati Raj system, 73rd Amendment. It balances power by maintaining federalism, by adjusting union-state relations, example GST Act 101 Amendment. The amendment helped correct legal issues by fixing loopholes in laws and governance, example NJSC Act struck down. The table lists some of the significant constitutional amendments and their impact. First Amendment 1951 added reasonable restrictions to fundamental rights, Article 19, and protected land reforms laws. Impact strengthened the government powers to implement social and economic reforms. 42nd Amendment 1976 added socialist secular integrity to the Preamble, curbed judicial review and expanded DPSP, which increased government power but later corrected by the 44th Amendment. 44th Amendment 1978 restored fundamental rights, limited emergency powers and strengthened judicial independence, which ensured that civil liberties cannot be easily curtailed. 73rd and 74th Amendment 1992 gave constitutional status to Panchayati Raj and urban local bodies, which strengthened local self-governance. 86th Amendment 2002 made right to education a fundamental right, Article 21A, which ensured free and compulsory education for children aged 6 to 14 years. 104 Amendment 2016 introduced goods and services tax, unifying India's tax structure, which simplified taxation, improved economic integration. Let us understand constitutional review and its key aspects. Constitutional review refers to the power of judiciary and examine laws, executive actions and constitutional amendments to ensure they align with the Indian Constitution. It is based on the below mentioned three aspects. Judicial review, where Supreme Court and High Court can invalidate unconstitutional laws based on Article 13. Laws inconsistent with fundamental rights are void. Basic structure doctrine, which ensure the Constitution's core principles cannot be altered. Keshwananda Bharti case 1973. Checks and balances ensure the executive and legislature do not exceed their powers. In this slide, we learn about judicial activism and its types. Judicial activism refers to courts playing a proactive role in enforcing rights and ensuring social justice. Below are the types of judicial activism. Public interest litigation allows any person to approach for social justice, expanded access to justice. Expanding fundamental rights, Supreme Court has interpreted right to life, mention Article 21 broadly, right to privacy, right to clean environment, government accountability. Court intervene in cases of corruption, environmental protection and human rights violations. Let us now find out about the election process and representation in India. What is the Election Commission and what is its role? The Election Commission of India is an autonomous constitutional body responsible for conducting free and fair election in India. Established under Article 324 of the Constitution, comprises Chief Election Commissioner plus 2 election commissioner. The below table mention the functions of the Election Commission and their respective responsibilities. The obvious function is conducting election by organizing elections for Lok Sabha, Rajya Sabha, state legislatures and the President and Vice President of India. It is also very important to ensure free and fair election by enforcing model code of conduct to prevent unfair practice. Specify electoral reforms by introducing voter ID, EPIC, EVMs and VVPAT to improve election transparency. It supervises political parties by registering new political parties and monitors their financial activities. The Election Commission is responsible to handle election disputes by resolving complaints regarding election misconduct and violations. Ensure voter awareness and education by conducting programs like systematic voters education and electoral participation to increase voter turnout. Let us look at the representation of the People Act. The Representation of the People Act governs elections and electoral process in India, ensuring free and fair elections. It is divided into two key acts. The first, Representation of the People Act 1950, focus on voter and constituencies, deals with preparation and maintenance of electoral rolls, provides for allocations of seats in Lok Sabha and state assemblies, defines voter eligibility, Indian citizens 18 plus years not disqualified, governs delimitations of constituencies dividing electoral areas, and Second Representation of the People Act 1951 focus on elections and candidates, regulates conduct of elections and disqualifications of candidates, list corrupt practices like bribery, booth capturing and false information, provide for election disputes to be handled by High Court, introduces the Model Code of Conduct to ensure fair elections. So, the significance of free and fair elections in democracy. Free and fair elections are essential for a strong democracy as they ensure public participation, accountability, and political stability. They allow citizens to choose their leaders and prevent dictatorship or corruption. Below listed are the significant aspects and importance of free and fair election. People's sovereignty ensures citizens have the power to elect their representatives. Political equality, since every vote is equal, preventing discrimination. Government accountability helps leaders remain answerable to the public. Peaceful power transition to prevent violence and ensure stable governance. Strengthens rule of law to prevent misuse of power and ensures justice. In this module, we study about the landmark judgments and case studies which helped shape the Constitution of India. The below listed landmark judgment by the Supreme Court of India played a crucial role in shaping constitutional interpretation. Keshwananda Bharti case 1973, the Supreme Court ruled that Parliament cannot alter the basic structure of the Constitution, which addresses the basic structure doctrine. In Maneka Gandhi case 1978, strengthened Article 21 right to life and liberty, stating it includes due process of law which address the expansion of fundamental rights. In S.R. Bommai case 1994, limited precedence rule Article 356 misuse and reinforced federalism, which addresses the federalism and precedence rule. In Vishakha case 1997 led to the establishment of guidelines for workplace safety later codified in law which address the sexual harassment at workplace. In Navtej Singh Johar case 2018 decriminalized section 377 affirming equal rights and dignity for LGBTQ plus individuals. Importance of constitutional interpretation. Constitutional interpretation is the process of determining the meaning of a constitution. It involves applying theories and methods to a constitution, text to derive meaning and apply it to specific cases. Maintains constitutional supremacy, ensure laws align with constitutional values, expands fundamental rights, strengthens citizen protection over time, balances power, prevents executive, legislative, and judicial overreach, adapt the changing times, allow the constitution to evolve with society. Let's go over some case studies on fundamental rights. Menka Gandhi case versus Union of India 1978. Issue Right to Life and Personal Liberty Article 21. Judgment expanded Article 21 emphasizing due process of law. Impact strengthened fundamental rights and personal liberty. Keswa Nanda Bharti case versus State of Kerala 1973. Issue Basic Structure Doctrine. Judgment Parliament cannot amend the basic structure of the Constitution. Impact ensured constitutional supremacy and judicial review. Navtej Singh Johar vs. Union of India 2018. Issue LGBTQ plus rights section 377 IPC. Judgment decriminalized homosexuality, upholding privacy, dignity and equality. Impact strengthened LGBTQ plus rights in India. Case studies on judiciary. Saira Banu vs. Union of India 2017. Issued triple talaq and gender justice. Judgment declared instant triple talaq unconstitutional. Impact strengthened women's rights and gender equality. Indira Sawhney vs. Union of India 1992. Issue Reservations and Social Justice. Judgment upheld OBC reservations but set a 50% limit. Impact balanced reservation policies while preventing misuse. Case studies on federalism. S.R. Bomai vs. Union of India 1994. Issue Misuse of Article 356. Judgment established that federalism is a part of the Constitution's basic structure. Impact prevented the misuse of President's rule. State of West Bengal vs. Union of India 1963. Issue Center vs. State Powers. Judgment ruled that states cannot claim sovereignty. Impact reinforced India quasi-federal structure. These historical cases on contemporary Indian politics had the following impacts. These cases highlight the importance of judicial interpretation in shaping Indian democracy. The Supreme Court plays a vital role in protecting fundamental rights, upholding federalism, and ensuring constitutional governance. Judicial activism has strengthened democracy, social justice, and individual freedom. In this module, we go over the contemporary issues and debates in the Indian Constitution. Here mentioned are some of the recent constitutional amendments and their implications. 101 Amendment Act 2017 GST implementation. 102 Amendment Act 2018 NCBCA's constitutional bodies. 103 Amendment Act 2019 EWS reservation. 104 Amendment Act 2020 SC/ST reservation extension end of Anglo-Indian seats. 105 Amendment Act 2021 state power to identify OBCs. 106 Amendment Act 2023 Women's Reservation in Parliament and State Assemblies. Let's look at the detail of few of these amendments. 101 Amendment Act 2017 GST implementation. Key provision introduced goods and services tax GST replacing multiple indirect taxes. Implications: created a unified tax system, enhanced of doing business and aimed at boosting revenue collection. 104 Amendment Act 2020 SC/ST Reservation Extension and of Anglo-Indian seats key provisions extended SC/ST reservation in legislatures till 2030 removed Anglo-Indian reserved seats. Implications ensured continued political representation for SCs, ST while altering the representation of Anglo-Indian. 106 Amendment Act 2023 Women Reservation in Parliament and State Assemblies. Key provisions reserved 33% seats for women in Lok Sabha, State Assemblies and Delhi Assemblies. Implications increased women political participation expected to influence policy decisions or gender equality. Let us now deep dive on the key historical debates. Debate on Uniform Civil Code. Let's discuss the argument from supporters and opponents of Uniform Civil Code. Supporters' argument ensures equality by applying the same laws to all citizens irrespective of religion, promote national integration and removes personal law-based discrimination, strengthens women's rights by eliminating regressive religious practices. Opponents' arguments threatens religious freedom and cultural identity of minority communities, may create social unrest due to resistance from religious groups, implementation challenges due to diverse traditions and legal complexities. Debate of Article 370. Special status of Jammu and Kashmir revoked in 2019. So let's discuss the argument from supporters and opponents. Supporters of revocation arguments strengthens national unity by fully integrating Jammu and Kashmir with India, brings economic development and improved governance, ends the dual citizenship and special privileges enjoyed by Jammu and Kashmir residents. Opponents of revocation argument undermined federalism and rights of Jammu and Kashmir residents, could lead to political instability and increased tension in the region. Critics claim the move was done without proper consultation with Jammu and Kashmir leaders. Debate on freedom of speech. Article 19(1) Clause A and reasonable restrictions under Article 19(2). So let's discuss arguments from supporters and opponents. Supporters of unrestricted free speech argument essential for a vibrant democracy and holding the government accountable, ensures expression of dissent, artistic freedom and media independence. Supporters of restriction argument. Hate speech, defamation, national security threats need reasonable limits, ensures social harmony by preventing communal violence, controls misuse of digital platform for misinformation and propaganda. So, what role does the Constitution play in modern India? The Indian Constitution serves as the foundation of governance, guiding the country in maintaining democracy, justice, and unity. Its role in modern India can be understood through the following aspects. Supreme law of the land defines the framework of governance and legal structure, ensures constitutional supremacy over the government actions. protector of fundamental rights and duties, guarantees equality, freedom, and justice to all citizens, balances individual rights with responsibilities to maintain harmony, guiding democratic governance, establish parliamentary democracy with checks and balances, defines roles of the executive, legislature, and judiciary, strengthening federalism, distribute powers between union and state governments, promote cooperative federalism while allowing central intervention when needed, adapting to changing provide amendments provisions to evolve with time, response to modern challenges like digital privacy, environment and technology laws, ensuring free and fair elections, empowers the Election Commission to conduct impartial elections, strengthens democratic participation and representation, enabling social and economic justice, implements directive principles of state policy to promote welfare policies, encourages education, health, and economic upliftment of weaker sections, preserving national unity and secularism, promotes unity in diversity while respecting cultural and religious pluralism, upholds secularism to ensure equal treatment of all religions. So there is the end of the presentation on mastering Indian Constitution. Thank you.